Good evening. I'd like to call to order the special Thursday, April the 4th, 2019 meeting of the Zoning Hearing Board. I invite everyone to join us in the Pledge of Allegiance. Thank you. We have a couple housekeeping things we're going to clear out of the way and then get to the agenda. First, this evening, Konstantin Economides joins us again as special counsel. Welcome again. Thank you for your assistance. Also, I'm going to note now, because he'll be running out of the building at the end of the hearing, that Raul Katari will be stepping away from this board and joining another township board almost immediately after his departure here. But we thank you for your time on the board and appreciate your service. Okay. Everyone has the agenda. We're actually going to work from the bottom up this evening. First matter that I'm going to call is Appeal 3029. The applicant, Villanova University, property located 800 East Lancaster Avenue and zoned PI, planned institutional. Applicant seeks to modify the conditions imposed by the prior decision of the Zoning Hearing Board in Appeal 1554, dated November 20th, 1980, regarding a grant of relief by the Zoning Board from the height requirements for light standards at the Villanova football stadium. Applicant requests that the conditions be modified in order to be consistent with resolution number 2006-05, dated February 14, 2006, of the Board of Commissioners. In the alternative, applicant requests a variance from section 280-64E of the zoning code, contends that the prior grant of variance did not impose conditions except for the height and number of the light standards, or improperly imposed any other conditions. Applicant further requests such relief from the zoning code consistent with the exhibits presented. Mr. Cornelia?
Thank you. Nick Canelli, representing the applicant, Villanova University. I believe you have before you a letter from John Rice, the township solicitor, requesting a joint continuance of both Villanova and the township regarding this matter. When I appeared before you, I believe it was 2 weeks ago, I mentioned that there's a good possibility that it won't be resolved before the next zoning hearing. Mr. Rice did send that letter out. It's a joint continuous letter. Both of us agree that we're working towards it. Towards a resolution. We have exchanged drafts, and hopefully we'll be getting together soon face-to-face to try to finally resolve it. I have given to Mr. Economides the letter granting the extension to the township. I'll give a copy to Mr. Kachansky as well for the file.
Okay, thank you. I will ask for a motion and then we'll have some discussion. Would anyone like to move the request?
I'll move to grant the request.
Second?
I'll second it.
Okay. Board discussion?
Yes. I'm not going to oppose the motion, but I want to cover the history of this matter. In mid-October, the township zoning officer notified the university that it was operating its lights in contravention of restrictions. The university filed an appeal in November prior to Thanksgiving. The matter was scheduled for December. At the December meeting, council said that they were unable to have their witnesses here in December. It was the first continuance request. We granted that continuance. The matter was scheduled for January. At January, council said, we're trying to work things out with the township, and we'd like a continuance so we can work things out. And by the way, maybe not to February, give us a continuance to March to give us enough time to work it out. And we granted that continuance. The March meeting comes, council returns. We're still working on it. We need more time. We'd like a continuance into April. At the time, the first meeting in April was for tonight, and you did caution that there was question in your mind whether you would have the matter resolved by tonight. So now we have the next request for a continuance. If the university was looking to build something, or if a resident in the township was looking to build something, this would be without significance, because the response would be, no skin off our nose, you can't build it until you have your variance, you can't build it until you have your special exception, take your continuance. I've been on this board now, this is my 6th year. There's never been a matter with more than 2 continuances. But the problem here is that since the middle of October, the university has continued to operate its lights without regard to the citation it's received from the township. So this effort of continuing has resulted in over 5 months of use of the lights, perhaps not consistent with the relief that was previously granted. Certainly it may be up to this board at some point in the future to decide whether that notice from the township zoning officer was providently granted. Because we've never had more than 2 continuances in the 6 years that I've been here, we defer to the chair. The chair hears it, usually agrees to a continuance. We've never even had a vote on a continuance. And I want to note that in our ordinance, as it relates to continuances, it says such request shall be made before the board, or excuse me, upon written request or verbal request, the zoning hearing board may authorize. So it is an act of the board, not an act of the chair. So what I'm saying to the members here is that I'm putting the other members on notice that this is it for me. If you're not ready for the next meeting, either proceed, dismiss your appeal, or we should dismiss your appeal. I practice law. I know how it works. If somebody doesn't give you a deadline, you kick it down the road. And the problem here is by kicking it down the road, you're spitting in the face of these neighbors who think that you're operating these lights not consistent with your relief. Obviously, I wasn't surprised that you got the letter from the township solicitor because you're a smart guy. It was appropriate to put his name on here instead of your name one more time and have to take the grief from me. But I suggest, Kevin, that you let the township solicitor know, get his act together. There's only so many variables. There's a certain number of nights, there's a certain number of hours, there's a certain number of months. You're either going to cut a deal or not. I suggest you get it done.
And Mr. Martin, just to let you know, we are anxious to get this resolved also because negotiations had led to Villanova obviously taking some positive action regarding the lights. And we want to be able to fulfill that by September if possible. So we have to actually do what we're supposed to do and actually get a contractor to do what we're negotiating to do. So we're really not trying to delay this. It's just a matter of trying to reach an agreement on it. And that's why these continuances have been joint at least the last couple times.
I have nothing else to say. Thank you.
Any other board comment?
I think it's a really valid point.
Bill, thank you for expressing your thoughts on this. I know that this is an issue that is a bit extraordinary in that the time that this has dragged out is far beyond anything that we have encountered. If it were simply, I have to take the letters we have received at face value. And we have both sides to a discussion requesting the continuance in this instance. Certainly, it comes after other continuances. We should be mindful of that. But ultimately, the accountability for the request for the continuance here lies with the university and with the township. The township took an action that has brought everyone to us here. And if the township solicitor is not requesting a continuance sua sponte, his client is saying, go get, a continuance is acceptable to continued discussions. So I find this continuance to be in the nature of the party that has commenced the enforcement action is saying, let's have a couple more weeks to talk. Now, I too am, though, not so optimistic that if another continuance were to come along, that we would be in a position to grant it. And Nick, I'm assuming that the request would be to be added to the agenda for the meeting 2 weeks from today.
I would assume that.
I'm sorry, 3 weeks from
28th,
today.
yes,
3 weeks from
20th.
today, excuse me.
Because I believe we're not having one on Easter week.
Correct.
It's gonna be
We're meeting the
following week.
25th. That is correct.
Right. And actually, that would lead to at least 2 commissioner meetings, so. Because remember, the commissioners have to approve whatever
Sure.
agreement is reached.
So I'm inclined to approve, or to agree, excuse me, to the motion as well, but I am with Mr. Martin in suggesting that you be ready to go on the 25th.
I understand.
Because there will not be another continuance. Well, I will not vote for another continuance.
I understand.
If that's all the discussion, I'll call a vote. All in favor of granting the continuance, please indicate by saying aye. Aye. All opposed? No? Thank you.
And I just have the letter for Kevin. As I mentioned, I gave one.
Great, thanks. Sorry, continuing to proceed backwards on the agenda. The next matter is Appeal 3035, the applicant Laurie and Timothy Gallagher, property located at 21 Longwood Drive and zoned R4 residential. Applicant seeks variances from Section 280-30E of the code to construct a one-story addition to the rear of their home, and Section 280-30D1 of the code to enclose an existing side porch. The rear addition will extend 3 feet into the required rear yard setback, leaving a setback from the rear property line of 27 feet. The existing side porch complies with the 12-foot side yard setback, but violates the aggregate side yard requirement of 30 feet. In the alternative, applicant contends that enclosing the existing porch is permitted since it does not extend an existing nonconformity, and as to both requests, such other relief from the zoning code consistent with the exhibits presented. Counsel?
Yes. Nick Keneally, representing the applicant. Just going to swear you in and ask you your name.
Ma'am, I swear you in, if you raise your right hand, do you solemnly swear or affirm that you will not
I do.
state your name for the record?
Laurie Gallagher.
I'll explain to the board what is occurring here. And some of it you'll see in the exhibits. Matter of fact, the photograph for the side yard actually shows the porch already enclosed. The Gallaghers purchased this from a prior owner who probably owned it for a short period of time and made some renovations to the home. And one of the renovations she made was she unenclosed this side porch. So we're looking to enclose it again. And in an abundance of caution, I'm asking for relief in order to do that. I don't know if we needed to. I actually, when Kevin saw it, he looked at the picture and said, "This is already done. Why are you asking for relief?" I said, "Well, they unenclosed it, so I guess we should ask for relief on it just to make certain." And the other thing that we're asking for is this addition here that basically covers an existing patio, at least extends back as far as an existing concrete patio. We'll show you some photographs showing that there's been many of these additions in the neighborhood. It's very consistent with the neighborhood. And basically, due to the size of the home, it's a very small home. The Gallaghers just bought it, just moved back to the area to be near their daughter and grandchild. And are looking to put an addition on to make it more feasible for them, since they are retired or about to retire, and seek the ability to basically use the first floor during their retirement. So this is a one-story addition that we're talking about. Lori, you and your husband, Tim, are the owners of the property?
Yes,
And Tim is seated right back here behind us? Okay.
yes.
And I'm going to show you what's been marked as A2, and you're going to have to talk into that mic. I'm going to show you what's been marked as A2, and this is... the
Mrs.
deed-
Cornelia, I don't, have we sworn the witness?
Oh, yes, I've seen
Yeah,
it.
You did-
yeah, yeah. I'm going to show you what's been marked as A2, and this is the deed, correct?
Correct.
And you acquired the property in October of 2018.
Correct.
Why did you buy this property?
We bought this property because when my daughter got pregnant, I was still working at MedImmune in Maryland, and MedImmune in Maryland, and this is our first grandchild, and we wanted to move back to the area. We actually lived 25 years in Harleysville, but when we moved back, we wanted to be closer to where my daughter lives, which is in Havertown. So the reason we bought this house, we had three pieces of criteria. One was that we were about no more than 20 minutes from where she lived. The other one, we wanted single floor living because my husband and I both turned 65 this year. And the third thing is we wanted to live in an area where there were a lot of amenities. And we were very familiar with Wayne before we moved back, and we loved Wayne, and that's where we wanted to live. And this house offered those things that we were looking for.
Okay, I'm going to show you what's been marked as A3, which is a Google map. And your property is outlined in black here. Is that right?
Yes. Yes.
And this line here, this is the line indicating where your addition would extend to, correct?
Correct.
And the other properties also show additions basically extending back to that line itself.
Correct.
And that's the reason why we have this photograph, right? Just to show that it's very consistent with the other homes in the neighborhood.
Correct.
What's the size of your home?
1624
Square feet?
square feet.
And that's gross square feet.
Yes.
All right. It's not just the footprint itself. It's actually gross square footage. All right. And your lot size is 7,000 square feet.
Correct.
And so it's a small lot, relatively small home on it. And what you're seeking to do is to add the addition to the rear of the property.
Correct.
And currently on the first floor, what rooms do you have?
So on the first floor, when you walk in the door, we have a living room, we have a powder room, and we have a hall closet. We have a eat-in kitchen, and we have a master bedroom, master bath, very small laundry room, and a walk-in closet.
So you have, on the first floor, you have no dining room,
No dining room.
No family room?
No family room, correct.
and no den or anything of that nature?
No.
And what are you proposing for this 14.5 by 28-foot addition?
So what we're proposing is a family room that will be 14.5 by 16 and a screened-in porch that would be 10 by 14.5.
The screen-in porch in
No,
this area?
this
Okay.
whole area won't just be family room. It'll be screened-in porch and family room.
Okay, and what do you have on the second floor? Of
On the
property?
second floor, we have 2 bedrooms. One bedroom we're now using as a guest room and office. The other bedroom is really being used to store a lot of family room furniture, dining room furniture, and a little bit of living room furniture.
You don't have much storage space
No.
in the house?
We don't have an attic, we don't have a basement, and we don't have a garage.
Now, I noticed that the proposal is for it to be 14.5 feet deep. Is there a reason why we're looking at 14.5 feet rather than the approximately 11 or 11.5 feet that would comply with the ordinance?
Because of the family room, we needed a space that's conducive to actually putting the furniture around, making it, it's still going to be cozy, but any less than that wouldn't be really that helpful.
Just showing you a couple more photographs. First, A5, and A5, what does that represent? Is that your house, the front of your
Yes,
house?
yes.
Okay. And actually, that does show the porch that was enclosed, correct?
Correct,
So this is the house before you purchased it.
correct.
And there's no additions on this house after you purchased it.
No.
And I'm going to show you what's been marked as A6. Can you tell the board what A6 represents?
That's the back of the house, and there's that sliding glass door going to the back, and there is a concrete patio where you see the furniture there, and also concrete coming out from the back door.
I'm also going to show you a series of pictures that I'll mark as A7. Not to delay the board, I didn't mark all of them. Here's one. And so the first picture in A7, that looks like the porch as it currently exists, the side porch.
Correct.
All right. And you heard us testify that actually the side porch does comply with the 12-foot side yard setback, but does not comply with the aggregate, which is the required aggregate is 30 feet, right?
Correct.
Okay. I'm going to show you the second picture in the packet. If you could tell the board where this picture is being taken. When was this picture taken?
Yesterday.
All right, and from where is it being taken?
It's being taken from our back door looking behind us. So what you're seeing is the house that's behind us.
So it's been taken from like this location,
Yes.
looking straight back?
Yes.
And what it shows like a large...
There's a fence, and it's the neighbor behind us has that fence. Those trees are on our property.
It shows it heavily ice buffered.
Yes.
Showing you what's been marked, again, the third picture in there, if you could tell the board where that's being taken from. When was it taken? Are all these pictures taken yesterday?
Yes.
Okay. When was it?
That was taken to show also part of the back property that backs up to the neighbor behind us, and that the tree isn't in bloom yet, but there is a lot of privacy. And then where our deck is, that also adds privacy to the yard on the side.
Showing you the next picture, which is a white fence.
So the next picture, what you're seeing is the house to the right of us. That's actually there.
Where on, when we say to the right, where are you talking? Here's north, east, west?
So if this is the porch, this is the backyard. It's this side.
Okay, so it's the western side,
Yes.
looking out from the west.
Yes. And what you see is a garage of the neighbor. So that's really what you're looking at, our fence and their garage.
Is it back in this, is that the garage we're talking about? It's listed
Yes.
as shed?
Yes.
And then finally, you have another white rail fence, and that is on the side where you're enclosing that
Correct.
porch? Okay.
Correct. And what you're seeing, the shrubs, that's forsythia. It hasn't started to bloom yet, but it lines, it's on our property and lines between the two properties.
That's all I have at this time.
Any board questions for the witness? No. Thanks.
Thank you.
You would request the exhibit to be part of it.
Without objection. Are there any members of the public that would like to speak to this application? Seeing none, I will request a motion on the application.
I'd like to make a motion in support of appeal number 3035, extending the back of the house and taking down the enclosed porch and giving them some relief.
We're closing.
And
Yeah.
closing, sorry.
In closing.
And closing.
Yes.
Second.
Discussion?
The hardship, is there, what would we suggest would be the hardship? And the
Beside the
size,
amount
the
of
size of the
furniture.
back room, I'm not sure.
No, yeah,
meets-
I would suggest it be the small lot, the small size of the home itself, and it is the minimum relief necessary. You really can't have a room that's any thinner than 14 and a half feet. It just wouldn't be feasible. It wouldn't.
What about the neighbors? Do you have anything from the neighbors?
I know they spoke to a couple of the neighbors. One is a renter, I believe, and there's, I know one of the neighbors works in my office building. I'm sure if he was concerned, he would have ran down to my office and said, "What's going on my road?" But I did not hear from him. I told Lori that yesterday. But go ahead.
The other thing that I had mentioned was what's really important to us and why we moved back is our grandson. And the one room, the bedroom upstairs, we want that to be a bedroom and playroom for him and other grandchildren that will come. But in order for that to happen, we need to move that furniture down and it's really functional living space that we're after.
Understand.
Okay.
Thank you.
And
There was
go.
no objection from any of the neighbors, on this. All the notices were sent, and
absent neighbor objection, and we don't have anyone opposing this application, I'm hard-pressed to deny the application. It's, it's a, it's not the most compelling showing of hardship we've seen, but by the same token, I don't think it's out of character with the surrounding neighborhood. It's not, 4 feet from the property line. It seems to be of a scale that is reasonable, and I would support the motion as well. Anybody else?
I would just further highlight, we hope that there really wouldn't be the hardship that would be coming would be, you would age some more and there would be even more of a need basically for this. So almost waiting for the hardship to happen that we would expect to be that much more of a hardship would not necessarily be in anybody's best interest. So I'm sympathetic to the fact that it doesn't appear to be a hugely compelling hardship today, but we wish you the best and hopefully that hardship won't come.
Okay, I'm going to call the vote to approve the relief requested. All in favor, say aye. Aye. All opposed? None? Good luck.
thank you for your understanding on this.
Sure. Okay, the last matter before us this evening is Appeal 3033. The applicant, Baron Gemmer, property located at 400 South Wayne Avenue and zoned R2 residential. Applicant seeks to appeal the zoning officer's determination emailed January 17, 2019 regarding the application of zoning section 280-112 steep slopes to the approval/issuance of the grading permit and building permit for the property as cited in the email. Applicant contends that section 280-112F does apply to the proposed development for the property and therefore seeks revocation of those permits. Applicant also seeks to appeal for reconsideration of jurisdiction from the Zoning Hearing Board's February 4th, 2019 written decision of applicant's Appeal 3027.
Good evening.
I do. Baron Gemmer, Baron Gemmer.
I have an entry by the property owner.
Okay, Mr. Gemmer?
Oh, good evening again. Given the two parts to my appeal, I didn't know what the board's pleasure is to look at the jurisdictional issue, because the underlying issues to both related to 280-112F are very much the same. There's a slight difference in the other one, so whatever the board's pleasure is in that.
Well, it strikes me that two different actions are being appealed, one being the grant of the grading permit that you were before us before, and then the request for reconsideration of that determination. And then secondly, it appears you are appealing the zoning officer's opinion that was transmitted electronically on the date you've indicated. So my sense, and a welcome comment from the board on this, and Gus also, my sense is we can take them separately. You may as well take the motion to reconsider first.
That's exactly what I was going to suggest, because you're going to, to do the reverse, you might be looping around again. So I would suggest, respectfully, that you decide the reconsideration, and then, depending on where that goes, decide the rest of the issues from there.
All right, let's, Mr. Cornelia, either the chair is breaking or you have thoughts.
First, never heard of a motion for reconsideration. The remedy here would have been to appeal this to Common Pleas Court, which wasn't done. There's nothing in the MPC that grants this board the ability to consider a motion for reconsideration of a denial of a zoning hearing. Basically, that acts as res judicata, and nothing's changed, nothing's different. As I said, it's beyond the jurisdiction of this board to consider a motion for reconsideration. The proper venue for this would have been the Court of Common Pleas of Delaware County.
Yeah, and admittedly, this would be my first in 5 years. And Bill, I mean, you've been here longer than I have. Mr. Economides, your thoughts?
I have to be honest, I've practiced land use law as well, and I've been involved in the township boards. I've never heard of a motion for reconsideration. My apologies. But with that said, I don't know that the code prevents it either. So I'd like to hear from the applicant and from Mr. Cornelia as to what,
Yeah, if you could kind of walk us through why you feel such a request
Yes.
is supportable in either the MPC or the zoning code.
First off, the prior decision was a dismissal without prejudice, so it wasn't a denial, as was alluded to. And what it essentially is a reapplication for that reconsideration, because what it was denied upon on jurisdictional grounds was that because it was a decision by the township engineer and that didn't fall under the MPC allowances for jurisdiction. Well, in re-looking at 28112, it does fall under one of the MPC jurisdictionals for you. So instead of appealing it to the Court of Common Pleas, or as was suggested last time to the Board of Commissioners, this is the appropriate venue. So there wasn't an appeal of a denial. It's saying this was the right venue. Please reconsider that based upon this new information of what the code intent was and how that applies to the MPC jurisdiction.
Has the MPC changed since we last met on this issue?
No, it has not. So it's more in terms of bringing it to light as opposed to that.
Well, I don't know. One could argue you had the opportunity to bring it to light when you were before us earlier. My point is, you didn't make the argument then.
Yes, I made the argument for the right MPC section. I didn't have the supporting evidence for it from the code section of Radnor Township Code.
Mr. Cornelia, thoughts?
Couple things. One, section 10909.1 of the MPC lists where the zoning board can have jurisdiction over. The first one is substantive challenges to validity of the ordinance. Not the case here. 3 is appeals from determination of the zoning officer. Now, we're going to talk about that later, but this wasn't a determination made by the zoning officer. This was an email. And it wasn't made to the applicant. It was a comment made to Mr. Gemmer. We'll talk about that. Then it talks about appeals from determination with reference to any floodplain or flood hazard ordinance, applications for variances, applications for special exceptions, appeals from determination regarding the transfer of development rights, and appeals from zoning officer's determination or 9106.2, which is not the case here. That's the case where you have a zoning officer issue a determination to a property owner. And then it talks about the appeals from determination of the zoning officer, municipal engineer for the administration of any land use ordinance regarding sedimentation and erosion control and stormwater management. Again, not the case here.
Can we stop there for a second?
Secondly,
Why,
Hold on, Nick.
hold, stop. Why do you state that conclusory statement? That's not what we're dealing with here.
which one?
The last.
The
No.
one- yeah.
It talks about stormwater management. That's not what, this was an appeal regarding steep slopes. And also.
Well, if we're going to argue the merits, can I put on that?
Baron, Mr. Gemmer, let it get one at a time. Let Mr. Cornelia go, and you'll have an opportunity.
Grading permits issued on October 4th, 2018. It is now April 4th, 2019, 11, 12, 1, 2, 3, 4. That's 6 months ago. He has 30 days to appeal this determination if he wished. He hasn't done it. This board denied it. His next step is to go to Court of Common Pleas, not back to this board asking for reconsideration. There's nothing in the MPC that states that you may reconsider a prior decision, which is what we're arguing about right now is reconsideration, I believe.
Well, he's being, Mr. Gemmer, let Mr. Cornelia have the microphone and the podium, if you don't mind.
No, go ahead.
And, Nick, are you done? Okay. Are you done?
I am, thank you.
Okay.
Mr. Gemmer?
Yeah, reconsideration issue aside for the moment, what Nick was going over with the MPC, and which is what I was discussing earlier, in terms of what.
Going to that argument
sure.
would be appropriate after we granted
All
the
right.
ability to reconsider.
Okay,
So
that's why I was
Please,
wanting
let's address Mr. Cornelia's objection regarding the absence of authority for this board to grant a motion to reconsider.
Okay. First off, in terms of the timing, I timely appealed that grading permit within 30 days. Actually, I wasn't even notified, but I still managed to appeal within 30 days. I came before this board, was dismissed without prejudice, and then upon receiving that decision, within 30 days of that, I made this new application based up for reconsideration. So that I don't think there's an issue with the timing. We can still talk about reconsideration, but.
Date of the grant of the grading permit was what again? Did you say October? So is there any contention that, Mr. Cornelia, is there any contention that that appeal was not timely? Because I suspect that the way the calendar works and the notice for getting put on agendas work, it sounds like he could have been on the December agenda if he submitted an appeal in November, but missed the deadline for the November meeting. Evan, do you have any visibility into that?
Well, 30 days is the submission timeline to get onto the board, so 30 days prior. So yes, he would have missed more than likely the November meeting, but would have been on the December meeting.
Kevin, was it on the December list, or do you have
I
the?
don't know.
Do we have the appeal there, or when it was filed?
Kevin. Date of advertisement, December 2nd, December 9th. Oh, date received, November 5th, 2018.
So that would have missed the November deadline, the deadline for November agenda. Yeah. So let's proceed on the assumption that the appeal was timely filed.
Your original appeal,
Correct.
not this one.
No.
We're not determining this one yet.
Not, well,
Well, hold on. I'm sorry. I don't want to burden our solicitor too much, but I'm told the permit was issued October 4th. Is that what the date?
Correct. It's in the packet, yeah.
Okay. The original appeal was listed as received November 5th. So that's 32 days. The question is, does your 30 days run from the date of
It was a
permit
Sunday.
or
It
date
was
of
a Sunday.
posting?
That was the Monday after that.
It
Monday
was a
after
Sunday.
Yeah. I knew it was I found out I found out like 2 days before that, so that's
The
why.
30th was a Saturday. I'm just looking at the calendar, so in all fairness to Barry. The 30th was a Saturday, the 30th day.
So, if I could ask another question of the solicitor at this point. Our prior action to dismiss without prejudice doesn't have any tolling effect, or does it? Or is that an argument someone would have to make? If I heard Mr. Cornelia perhaps suggest that this new reconsideration is somehow a new appeal and not having been submitted within 30 days of the issuance of the grading permit, this new reconsideration / appeal is somehow non-timely.
Well, we are a quasi-judicial board, and judicial boards do consider motions for reconsideration. So that's why I don't, if the municipal planning code doesn't prevent it or prohibit it, I'm inclined to think that you can, if you want to, if you feel that the circumstances warranted, and the facts and the law warranted, I think that you can, if you want to, reconsider a decision that you made previously. Now, there's all types of arguments that I think have already, Mr. Cornelia has hinted to in terms of waiver and other issues, and whether or not this is even the appropriate board. But if we're talking about whether or not you can reconsider that decision today, I'm inclined to think that you can. As unusual as it is, there's nothing in the code that prohibits that. So I don't know why you can't proceed it that way, if the board so chooses.
Just, I respectfully disagree with Gus on this. The MPC lists specific reasons or specific matters the zoning board can have exclusive jurisdiction over. None of them say a reconsideration of a denial of a prior zoning hearing. All of them deal with, as I mentioned, I had told the board I can hand up the copy if Gus or anyone wants to see it.
Should I?
10-909.
It's
909? We have.
909.1A9.
We haven't, Mr. Cornelia, thank you.
You've got it.
101A9 says appeals from the termination of the zoning officer or municipal engineer in the administration of any land use ordinance provision thereof with reference to sedimentation and erosion control and stormwater management insofar as the same relate to development not involving Article 5 and Article 7 applications. He is contending about a steep slope ordinance.
Well, I'm confused. Are we getting back to the merits
Well, I'm
again?
just saying,
I'm going to allow a certain amount of discussion to address relevant jurisdictional issues. If we can't hear a request for reconsideration, we can't help you. But if people have thoughts as to why we can or why we can't, we'd like to hear those thoughts. And that issue is perhaps independent of the fact that the subject matter of the appeal is a steep slope ordinance or one of the other enumerated bases for jurisdiction for this board. Okay, so separate out the merits from the arcane jurisdictional issues we're now trying to work our way through. Okay?
Would you like to hear? Okay.
I would.
Yeah, okay. As the solicitor says, there's nothing prohibiting that in those MPCs, and you could really, even though I phrased it as a reconsideration, because it was dismissed without prejudice, and now that in looking at the code feel it's appropriate, I could have just brought it back without using that language to you and said, reconsider it. If it was a denial, that would be one thing. Then this would not be the appropriate forum. I would need to go to the Court of Common Pleas. But because it was dismissed without prejudice, I think we're getting stuck on my phrasing in terms of the reconsideration of the jurisdiction, where I could have just possibly put it in different language and said, I'm appealing this straight out from the beginning. Excuse me, so I'll put between the MPC not explicitly prohibiting it and the fact that it was not a denial, and it's maybe the wording we're getting caught up with, I believe that it should be allowed.
Okay, and speaking hypothetically, if we were to conclude that it's appropriate to hear this reconsideration, are there other jurisdictional reasons why we should not hear the matter? Namely, is the underlying contention one that's listed in 909.1A 1 through 9?
Yes.
And I believe there may be a disagreement on whether the subject matter jurisdiction, if you will, exists for purposes of this board.
Yes, I believe that's correct. Would you like me to?
Yes, I'd like.
Okay.
Why do you believe we have jurisdiction to hear this?
Okay. And I don't know if we want to start marking exhibits to keep things in.
We're going to be referring to them. Let us know, and we should be keeping track of them very carefully.
Start with the application itself as A1. I'll go a little out of order in the packet that you originally had, but.
I think the discussions are still around the code.
All right, well, I was going to offer.
But-
I just have a question. I mean, the board denied this same relief, saying they didn't have jurisdiction to make determination, and he's raising the same issue again. So nothing's changed.
That may be the case. My inquiry is directed toward the issue of whether there is an enumerated basis for jurisdiction. Even if we hear the reconsideration and give the same answer or give a different answer, clearly the applicant feels that they didn't make an adequate run at it last time and they want to take another run at it, and I understand that. But the issue of whether we have subject matter jurisdiction still remains open until we conclude that we do.
Okay.
And as I mentioned, the MPC is very specific on what Board of Commissioners, Board of Supervisors, and zoning hearing boards can make rulings on. And they don't say just because we don't list it, you can do it. It is specific to these reasons.
Well, the section you're referring to talks about jurisdiction, what the board has jurisdiction over. That's what 901 says.
That's correct.
So I'll refrain from labeling those packet ones if you want while we still talk about it, if you'd prefer that.
Well, what I think the board's trying to tell you is just focus on what the specific question you're being asked right now.
I'm not going to label all of them. I was just
Right.
going to label the ones I was going to go over right now.
Okay.
That's fine.
Okay. I won't even bother with right now, the packet that has the old appeal in it and the dismissal without prejudice decision from you. I believe it's the last page in your packet that has the 281.12 slope controls at the top, and we can label that A2. And per what Nick was saying and going through the MPC 9091A jurisdictional listing, and so looking at number 8, which he's already mentioned, appeals from the determination of the zoning officer or the municipal engineer, which was the case with the grading permit.
I'm sorry, is that sub 9 or sub 8?
Sub 9. I used to be sub 9, I think, in the old one. It's sub 8 in the new. I don't know what year the MPC changed, but I think it's only 8 now.
Oh, okay. All right.
Although, if you look in the next section, it makes an erroneous reference back to 9. So that's
Okay, so
understandable.
it's 8. All right, thank you.
So appeals from the determination of the zoning officer or municipal engineer in the I apologize. Appeals from the determination of the zoning officer or municipal engineer, which was the case in this grading permit, in the administration of any land use ordinance or provision thereof with reference to sedimentation and erosion control and stormwater management insofar as the same relate to development not involving Article 5 or 7 applications. So just to be clear, looking at the top of that page then, and then I can go over the specifics of the other articles, but 28112A, which talks about the intent of this section, and this is what all the 28112D, E, and F, which I've been talking about, the intent is to control the development of land in areas containing steeply sloped land for the following purposes. 1, to limit erosion and sedimentation. 2, to protect watersheds and limit increases in stormwater management. And the rest are along those lines, but those are the three things that were enumerated under 8.
Was the township engineer making a determination under that section, or was the township engineer acting under the grading ordinance that's in effect in the township?
He made that decision, or helped that decision, because I brought that to his attention, and so he considered that before issuing the grading permit.
Where's that reflected in the grading permit?
That's reflected in an email back from him. He made.
Do we have that?
Yes, I believe actually it might even be part of your packet, or I have an extra one. Hang on, let me see if that's part of the current packet or not. No, I have that separate. Hang on.
The point here being that the township engineer typically will operate within his or her sphere of expertise.
Understand.
And generally, from what I understand, though it's not a zoning matter, the application for and granting of grading permits is covered by Chapter 175 of the Municipal Code. And that section has a provision as to how you appeal at least denials of grading permits.
Yes, exactly.
So the question here, and bear with me on this one, if it was appropriate, if you were an applicant for a grading permit and you were denied, how would you appeal that?
Per what you said, because 175 does have provisions for applicants who are denied.
But 909.1A8 of the MPC grants exclusive jurisdiction to appeals from the determinations of the zoning officer or the municipal engineer in certain in the fashion that you're describing. Mm-hmm. So how is the provision in the grading ordinance consistent with the MPC, just based on the fact that a decision went one way as opposed to the other?
In certain cases, it may not be consistent. I mean, I'm not going to argue. In a lot of cases, it won't involve sedimentation or something there specifically.
Mm-hmm. But what if someone brought the same issue to the attention of the township engineer when considering a grading application, and they raised issues about steep slope and other matters, and the township engineer denied the application, mm-hmm. and the applicant for that grading permit then wanted to seek an appeal, albeit an appeal that at least in substantial part rests on the determination of the township engineer as to a matter that you feel is in contest here. But he has to proceed in accordance with the grading ordinance, and you get to come before us?
No, well, actually, in the one case, I'd say there's a conflict, so that it could be debatable which way the applicant for a grading permit, if he's denied doing it. In looking at the grading permit, the grading denial process, that's all it says. So in my case, this is the recourse, whereas the other, for an applicant who gets denied, there could be some confusion about what the jurisdiction is. I don't disagree with that. I read that section.
Okay. Thanks.
Do you have the email in question to share with us?
Yeah, I was going to try and.
Are you looking at the email from
No. No, I'm sorry. No, it's from, I think I have copies of it. Hang on. Actually, I know I have copies. It's a matter of finding it. Here we go.
And do you have a copy for Mr. Cornelia?
Yes, I do. I apologize, I have limited copies because I was only using the part. I'll do this one.
Would this be A3?
Yes, as long as we're doing it, make it A3.
I'm sorry. So for those of us that do not have a copy of that in front of us.
Yeah, he
here we go.
conferred, I had emailed him,
Mr. Chairman, would you like me to make copies of that for the board?
Yeah. Yeah, Kevin, I'm sorry. Could we, it's going to be helpful to the board to have copies of this. Bear with us for just a
oh,
second.
no problem.
Mr. Gemmer, can you at least identify it's an email to who and what date?
Yeah,
From who? And
this is an email from Steve Norsini to myself, copying the township manager, Bob Zienkowski.
Steve Norsini being the township engineer.
Correct. And just to clean up some loose ends while that's going on with what I read on the MPC, just so there's no confusion, let me get back to A2 there, that under 9091A8, that land use ordinance, the definition of land use ordinance in the MPC, I want to make sure that we're good on this, is anything from Articles 4, 5, 6, or 7. 4, 5, 6, or 7 include zoning, which is Article 6. So this is 280 is part of that. But then it excludes Article 5 and 7, and 5 and 7 are subdivision and land development, which this is not a part of, and 7 is planned residential development. So just to make sure that we're clear on that it says it will cover zoning.
While we're waiting, not to derail us here, but if I recall correctly, when this came before us before and it was dismissed without prejudice, the part of the reason that it was dismissed without prejudice was to sort out this jurisdiction issue. And I don't have a complete recollection of it, but that there was some thought about going, I think, back to the Board of Commissioners, right, to determine whether or not this was under their jurisdiction. And did you take that action? Did you go back?
No, when that was Mr. Martin's suggestion, I believe, and I wanted to look to see where I thought it was, and looking through all the code, and then when I was rereading the jurisdiction for 9091 A and B, which speaks to the Board of Commissioners for the others, then I was rereading 28112 and realized, wait a minute, this is sedimentation. I realized when I read it first, when we were here at the first appeal, seeing that it was for the engineer and there's an engineer had a couple things that were jurisdictional under your purview, not thinking either applied until I realized that the intent of 28112 explicitly says that. So that I didn't go back to them because when in researching it to figure out where should I go, Court of Common Pleas, Board of Commissioners, or was this the right place and I just didn't know it? And that's the conclusion I came to.
And so I'm curious, Nick, from your standpoint, let's put aside, let's pretend, again, as a hypothetical, that this is not an appeal, that this was the first time that we were hearing this matter, basically, or that anybody was hearing this matter. Should this, as a first-time appeal, gone to the Board of Commissioners, the Zoning Hearing Board?
In the past, this matter would have gone to the Board of Commissioners. It's an appeal of the Township Engineer's decision. There was a prior decision of the Zoning Hearing Board. I don't know if anyone was members at that time, where a similar question arose, and the applicant was told to proceed to the Board of Commissioners, and the Board of Commissioners was the proper jurisdiction to hear this, not the Zoning Hearing Board.
And is there a reason, Mr. Gemmer, then, that besides the fact that you reread, some of the code that would have ended you with a determination that it belonged here again, that you that you wouldn't pursue basically this appeal with the Board of Commissioners? Do you feel like they are, in some way prejudiced to this, and that you'd have a better chance at the zoning hearing board to get this approved?
No, not at all. After taking into consideration when it didn't fit one of the enumerations, I reread everything and just came to the conclusion that this was the board. I would have happily gone to the Board of Commissioners. They don't charge a fee for their appeals, so I would have had no problem with that. I felt this was the appropriate board for it, based upon the number 8 with the sedimentation.
I'm looking at A3, and I'm not certain which particular email that Barron's referring. Now that you have copies of it.
Oh, thanks.
So again, could you call to our attention the particular email in this set that you think we should look at?
Yes, that's fine. Let me just make sure I don't give you too much here that you don't need. Basically on the November, because I was reminding, this thread had a couple of things in it unrelated to 400 South Wayne, but basically on November 1st and November 2nd, then Steve is emailing back saying that he's using, albeit the advice of the solicitor, but he made the decision on the advice of the solicitor to go ahead and issue it, despite the argument I made in terms of 280-112F.
Is that your characterization of Mr. Norsini's email of Friday, the 2nd of November?
In terms of that
It appears to me that Mr. Norsini is saying that once the solicitor informed me that the project did not fall under LD, which I assume is land development, I had no means to further delay issuance of the grading permit.
Yeah, and if you want to look back far, let me see if I can find farther where I make this argument, because I think there might even be let me see here, hang on. There was another email that I had sent directly to the solicitor and to Steve, which sorry these got separated out in terms of their relevance. Oh, actually, I think that's part of your packet. My apologies. It's the second email in your packet that's from me, dated June 26, 2018, to Steve. That's where I lay out the 28112F argument to him, and that's what all these subsequent emails were on. And the response being that it just wasn't under land development. I'm making the argument that it didn't need to be under land development. It said that all development in these circumstances need to go through that process. And
What emails are I see Steve's dated November 2nd, and then...
No, there's one dated June 26th. I think it's like the second, it's the...
Can we mark that A4
Yes,
for
please.
identification?
Yeah,
Please provide a copy to Mr. Canary.
Which one's
it's in
June?
it's in the packet.
It's in your packet.
Got that.
Yeah, that's not a separate handout. They got separate, the threads got separated because originally I sent this to Steve, and then there was another thread that was already going with 2 different topics, so that's why they're unfortunately not together.
I don't know if I have that. Is that?
I can get you. And Nick, that's A4.
This is just an email from you? Is that what we're referring to?
Yes, that's what I sent to Steve to start this process.
But,
And that's,
okay, it's not from Steve Norsini. I thought you were mentioning there was an email from Steve Norsini.
no, to Steve Norsini. There's one from A3 is from Steve Norsini, the one you already had the copy, and we just got the copies of.
So putting the puzzle pieces together, your position is that the issue of the applicability of the steep slope provision of the zoning code was taken into consideration by the township engineer in making the determination to grant the grading permit. Is that correct?
I think that's a great summary of it, yes.
Okay. Mr. Cornelia, any thoughts on that before we discuss it as a board?
Well, all that I see here is that it wasn't a matter for land development, and as a result, they issued the grading permit. Because I believe that was Mr. Gemmer's argument, that it was a matter for land development.
Mr. Cornelia, can I ask you a question? Is it possible that the grading permit was granted because the steep slopes weren't being disturbed? Is that the other issue? Because I know that's, I was reading this packet and the use of the words, not the land development, because I think if this board decides to reconsider, and I don't even know that we've gone over that hurdle yet, but if it does, then we're approaching it to the substance of the issue.
Right.
And if it was granted because the slopes weren't being disturbed, then there's no need to go to planning. And I don't know that Mr. Gemmer would disagree with that.
Now, I think Mr. Gemmer initially was arguing that because the slopes were any slope more than 14%, even if it's an addition, you have to go to land development, which is totally contrary to the MPC. The MPC controls land development, it says for a subdivision, not if someone's building an addition or a single building on a lot. But I think that was his argument, that it should go to land development because there was a slope of more than 14%. And if you look at the code, that provision in the code was like 1975 or something, and I think the MPC was 1980 or somewhere around there, So,
Well, are the slope, is that 14% slope or more being disturbed in this?
Well, remember, steep slope is 20%
Right.
or more. So I think Mr. Gemmer's argument is that any lot that contained 14% or more steep slope, no matter what you were doing, if you were doing something, you had to go to land development.
Right, but my question is, with this particular lot, is that slope being disturbed?
14%, it possibly could be. I don't have the plans.
Because I saw an email that suggested that it wasn't.
Yeah, there is.
Right.
Yes. Going to the substance, no steep slope is being disturbed.
Okay, that's what I was.
So and
if we even get to that point, that's where I wanted to.
Yeah, I keep being the back end all the substantive arguments.
No. Well, we're like as the chairman said, we're having a discussion right now to try to work out these issues.
Understand.
And you've marked some exhibits.
Okay, Mr. Gemmer, is there anything else you'd care to offer on the question of jurisdiction to hear the request should we grant reconsideration?
The only other thing I would say is, particularly with the timing issue, I'm aiming at a moving target here because I just did a right to know and was at the township yesterday, and the grading permit was revised yet again within the last 2 weeks. Still the same one, but
that's not a matter that's before us.
I know. I'm just
yeah. There are other.
Yep.
So I take it there's nothing else.
As far as jurisdiction,
Okay.
yes, I'm.
Amelia, anything else?
argument.
Can we discuss before a motion? Let's discuss before a motion. What do we do with this, fellas?
Can I, for me, there's three questions. Beyond the jurisdiction and then the substance question, there's another question to me which I'm unclear on, that's been brought up here what is the distinction between a dismissal versus a denial? Like, has this already been adjudicated on? Have we?
No, the without prejudice aspect of our earlier action means that the applicant is not precluded from making another appeal.
Okay.
The ramifications of timing and timeliness and whatnot, I don't think any of us gave much consideration to when we took action in December. But the applicant is not precluded from having his chance to make his case.
So on that first question then, am I correct in saying, to Mr. Gemmer's point, that we should be considering this as if it's the first time we would be hearing this, if it was our jurisdiction?
Right, and that's why we went through the very exciting jurisdiction
Yes.
colloquy we've
Right.
gone through this evening.
Right. And the jurisdiction question, as I understand, partly from Nick's argument, there's some precedent that would suggest that this belongs at the Board of Commissioners. There's some ambiguity in the code as to where this potentially belongs. So that's really a judgment question that's being left to us, basically, at this point, on the jurisdiction question. And then there's the substantive questions, which we can get to, later. But I just wanted to make sure I've characterized that all correctly.
I'm in agreement with that characterization.
Okay.
And if I may, since another argument's been brought up, just quickly, nothing's really changed from the last time you said there wasn't jurisdiction to today. So, and my impression was without prejudice, it meant go to the Board of Commissioners, but I could be mistaken. I didn't know that you could
That
come
was-
back and ask, you go for the same question before the zoning hearing board
That
again.
was the suggestion, but that technically wasn't part of the decision, was just dismissal without prejudice.
Sure, but I do think it was a suggestion of this board, the last time it came here, was that it should, it should be taken to the Board of Commissioners, basically. And if the Board of Commissioners then said, this doesn't fall under our jurisdiction, then we would hear it again without prejudice, potentially. If I'm correct, if that was kind of the suggestion, Bill, that I think that you had kind of made in December.
And I took that suggestion to heart, and that's
Yeah.
when I reread both of the MPC sections, A and B, and then realizing what 28112 said is like, no, I think I really do belong here. I would have, otherwise wouldn't have happy to go back.
Yeah,
to
but
the-
that's not the base, that's not the roadmap that we provided
Right.
for you last time. Google Maps recalibrated and came up with a different idea, which was, why don't we reread the MPC? And that's why you didn't go to the Board of Commissioners,
And I
correct?
took that as just a
And
suggestion.
is there any sense that the Board of Commissioners wouldn't have considered? I mean, I haven't heard any indication that that forum was not available to you.
Agreed.
But under what statute would I have appealed to them?
Well,
I can't, not 175 doesn't allow it, and under here, we're looking at the MPC. MPC says to come here. I wouldn't have had a leg to stand on to say they had jurisdiction.
I think consistent with the discussion, you would have said to the Board of Commissioners, well, the zoning board sent me here, they said you had jurisdiction. Board of Commissioners says, we don't have jurisdiction, then you come back here, and then you would have had a clearer argument before us.
Yeah, well,
That's-
and I was just thinking of time is of the essence. That's why I refiled as soon as I got the decision from you. And
any other thoughts?
Well, it's not lost on me either I'm not sure about the timing issue, that if you just went to the Board of Commissioners, it would seem to me that it would have been a quicker, kind of route to kind of get this resolved. But if we go through this again and say it's not our jurisdiction, you could take this to the Board of Commissioners, and the Board of Commissioners could then say, this does not fall under our jurisdiction, go talk to the zoning hearing board. Correct? That could happen again. And we could be sitting here, at that point, we would acquiesce and we would say, okay, yes, this doesn't belong anywhere else, this belongs with us.
You'd be off the board by then.
Yeah. Great, you're right.
Some of us will be here for that.
But also, the real forum for this, probably back when the initial decision was rendered, was common police court, which wasn't done either. And now, these people are sitting on a building permit for the last 6 months, concerned about what's happening here. Should they start building, not start building? And they've been prejudiced. Second time I've been back on this, and I'm sure Barron's going to continue coming back to some board or whatever, fighting this, knowing Barron, they'll continue doing it. And I'm not disparaging Barron, I just know how Barron, Barron's very intent on what he believes in.
I'm just trying to get my first bite of the apple here, really.
But could we, to that point, a cynical person could say, look, there's been some delay tactics here, right? Because it could end up at Board of Commissioners, and it could end up back with us, and then in the meantime, things have been delayed longer than they otherwise would have been delayed.
Yeah, and I have not made any delay. Literally, if you look at those emails, I found out like 26 days after the permit had been issued, and rather than use my constructive notice, I wanted to get within the 30 days. So that's why I filed that Monday, like 4 days after I found out. That got on the December hearing, dismissed without prejudice. Within, I think it was 10 days after I got the notice, because I had done the research then, I refiled. So I have not been delaying in any way on that, other than if you think I should have gone to the Board of Commissioners, which I didn't.
Right, that's the only, I agree with all the others,
Yeah.
but that this last step, somebody cynically could say, look, this was, a little bit of a delay tactic. I'm willing to take you in good faith that was not the case, but somebody could be making that argument.
And then obviously we had this meeting delayed 2 weeks. But sorry.
Sure.
Any thoughts from the solicitor before we consider a motion?
No, I mean, I've said my piece. I've taken a look at our application and the procedures that are attached to that talk about you being a quasi-judicial board. The MPC itself, for example, continuances are addressed specifically in our township code, for example, but they're not in the MPC. I mean, that's something a court does. The MPC doesn't say anything about you granting continuances, but the township's granted you that right, and you've exercised it, in fact, earlier today. And I think that the issue of reconsideration is something that courts do. And I think if this board is inclined to reconsider its own decision, is what's happening. I mean, it was a decision telling an applicant that you didn't have jurisdiction, and he's asking you to reconsider that. So if you're inclined to do that, I do not think that the MPC prohibits it. Mr. Canelli is absolutely right. It doesn't affirmatively grant it either. But the 909, Section 909 of the MPC Code talks about what issues, subjects, and cases you have jurisdiction over. So the subject matter of this appeal and request for reconsideration, you do have jurisdiction over. But I agree, a motion for or an application for reconsideration to a zoning board is quite unusual.
And what of the argument that we've heard that the prior action was res judicata with respect to the matter?
What prior matter are you specifically referring to? That's
The dismissal for want of jurisdiction.
well,
Which does not strike me as something that would give rise to a claim of res judicata.
correct.
And Gus, to Mr. Gemmer's point, is there an affirmative stipulation somewhere that would suggest that this belongs at the Board of Commissioners?
I think the argument has to do with the grading permit. That appeals from denials of grading permits are to go to the Board of Commissioners, and the argument by implication is that this circumstance being the appeal to the issuance of a grading permit is so peculiar that it was not addressed, but the fact that the ordinance anticipates appeals to the Board of Commissioners from the one sector is persuasive that that is the better approach. That's the argument there. Mr. Chair, can I suggest perhaps that we give the parties one last chance to say what they want to do and then have them put the mics down so we can perhaps entertain a motion?
That's an excellent suggestion. Final thoughts on the jurisdictional issue, please?
I would just say, in looking at 175, as is just stated by Mr. Martin, it says what can happen for an appeal of a denial, and that, the Board of Commissioners, I could go to the Board of Commissioners and they could say, no, we don't have jurisdiction of that. And even more so, I think in looking at this particular ordinance in which I'm using as my reason for objecting to the permit does fall under your jurisdiction with the MPC. So I'm hard pressed to try and make it fit within 175, which it doesn't address it at all, versus a place where it actually says in this particular instance it fits because of the sedimentation and stormwater and erosion.
Thank you. Mr. Cornelia?
Oh, stay there. Okay. Just two things again, and to reiterate, I don't agree with Gus on the jurisdiction issue, but we'll get over that. But what's being requested here was the same thing that was denied last time. It's clear this is not permitted. Nothing's changed from the last time till today. So even if there is an area where this board can exercise reconsideration, it still comes down to jurisdictional issue, which is not appropriate before this board.
Thank you. Would someone like to make a motion for consideration?
Can we invite the parties to stand down so we have no more interruptions? I'd make a motion that the appeal be denied for a lack of jurisdiction, that it be done clearly with prejudice, with the stated intent of this board that the matter not come again before this board unless new circumstance would suggest that we need to consider it. That's my motion.
Is there a second?
I'll second that.
Discussion?
I think this is a close call, and I think both parties have very effectively made arguments on their behalf. And I think it sort of falls under the category of, I mean, the facts haven't changed. Essentially, the argument's more effective. I mean, I think that's sort of where I am, which is the facts have not changed. Some issues related to potential jurisdiction have been pointed out with more clarity to the board. But I think that we need to make a clearer determination and try to avoid being in the circumstance where this comes back around. And I think that the answer is that this was a determination under the grading permit ordinance, and the better interpretation of the ambiguous law is that that should be appealed to the commissioners.
I think you stated it well. I mean, I'm inclined to agree that there hasn't been new information presented, and so in the absence of new information, a better argument, has been articulated after further, kind of reading. But I don't know that it changes, where we would have come out the first time, basically, because it is a little bit ambiguous, and I'm sympathetic to the fact that it's a little bit ambiguous. But the suggestion that was made at the last meeting still seems to me to be the appropriate suggestion, that this should have gone to the Board of Commissioners, and they could have made a determination to say that belongs at zoning hearing. So the only slight, discussion that I would have is if the Board of Commissioners says this belongs to the zoning hearing board, and I know I can say this because I won't be here if it were to come back. I don't know that technicality should preclude it from being here. Again, I know it's a close call. And I'm not suggesting that it really is meant to be here. I'm just sympathetic to the fact that that could be something the Board of Commissioners says. And Gus, I don't know where you fall.
Well, no, the only and I hesitate ever to interrupt your discussions on a motion, but I think we should be very hesitant. In fact, I think we should not make any suggestions to either of the parties as to what they should do. We should not be giving them legal advice. I think it's all because there's all kinds of issues with waiver. Make a decision based on what you've heard today. It's up to the applicants, both sides, to determine what avenues they can or cannot approach, because that I think goes, it'll just muddy the waters.
I have a question. I was hesitant to jump in. This is all new to me. So, but really, the motion that's currently before us, isn't it related strictly to whether or not we're going to grant reconsideration? Or are we actually going to determine on the merits at this point?
Well,
I was presuming it was just on standing and we were not getting to the merits.
I am not a litigator. So I may have a muddied concept of some of the things that I'm about to say, so I apologize in advance. If we make a determination to grant reconsideration, we're doing something that may well be unprecedented in the history of this board, and without clear authority to do so. Yes, the MPC doesn't say that we can't. It doesn't say that we can. And generally speaking, I have always viewed this board's jurisdictional limits as circumscribed by the ordinance and by the MPC. And it's, you know, I try to think of this case in that way and within those constraints. We're almost, I'm not suggesting that we're we're sitting as some quasi-judicial court of equity, but, you know, in many respects, a lot of what we do smacks of that process as well. And I want to be mindful to be fair to all of the parties. Those that we directed to go in a particular direction when we met in December, and parties that have been granted permits to proceed with a project. And you know, the fairness to both sides is paramount in terms of what I'm thinking of. The idea of kicking the can down the road to the Board of Commissioners and them sending it back to us, just because they send it back to us doesn't mean we have any more jurisdiction then than we have today. And you know, there would be several actions that would be subject to challenge at that point, not simply the determination that we should hear the case. So while I'm, you know, mindful of the thought that some have that the Board of Commissioners is the appropriate forum to hear this, they could, you know, they could say send it back, and I might still disagree, and others might still disagree and might challenge those determinations. So there are a lot of variables floating around. I am ultimately, at the end of the day, of a mind, and in, you know, again, exercising the equitable notion again, there's no changed circumstances. There's nothing different today than there was in December, but for the fact that we've heard a similar argument made in a more comprehensive fashion. And if that's the basis upon which we make a determination to grant reconsideration, I don't think that's fair to the parties. The parties had the opportunity to make their case in December with respect to whether it was appropriate for this board to hear this appeal. The fact that they make that argument better in April doesn't give us any more, you know, jurisdiction at this point. We've made a determination to dismiss this matter for want of jurisdiction. And I have heard, you know, thoughtful arguments on both sides, but nothing that leads me to conclude that it's appropriate for us to undo what we did in December. So I'm going to support the motion. Any other discussion? Okay, I'll call the motion to a vote. All in favor of granting the motion to deny reconsideration, please indicate by saying aye. Aye. All opposed? Okay, that portion is completed. Shall we continue?
Oh, great.
What
else? Oh, do we have some? Yeah, that was just the second. I'm sorry. That was just the
That was the
second part two.
I indicated early, Nick. This is a bifurcated exercise here. Let's take a 5-minute break. We will reconvene at 8:35. Thank you.
Get some water.
calling the meeting back into order. We have a second portion of this matter, which relates to an opinion of the zoning officer. Mr. Gemmer, would you like to let us know what this is all about?
Yes, and I believe, are we up to A5 in terms of exhibits? So A5, yeah, A5 will be the email to Kevin from me, probably the next one in the packet, I believe, January 21st, 2019. And I'll go back, it's his opinion is farther back in that, but I just want to make sure everybody gets to that email first. Okay. So just, I'll give you the brief synopsis of the email, and then we'll get to the opinion. Kevin had actually emailed out because there were concerns with the plans about actually disturbing steep slopes. It had been mentioned earlier, and I was copied on that. So I sent the email back to Kevin saying I shared that concern, and also bringing up the issue of 28112F with that building permit as well as the grading permit. And then I believe on page 4, that's where you'll see his opinion. After reviewing your concern regarding zoning ordinance section 28112F, it is my opinion that the provision is not applicable to this property and the current proposal and grading permit. Oh, I'm sorry, I was popping my piece. Okay, I'll repeat that. Kevin's note is, Baron, after reviewing your concern regarding zoning ordinance section 28112F, it is my opinion that that provision is not applicable to this property under the current proposal and grading permit. Zoning ordinance section 28112F requires lots which contain steep slopes and are to be developed to be reviewed by the Planning Commission and approved by the Board of Commissioners in accordance with the requirements and purposes of Chapter 255 subdivision of land. The project at 400 South Wayne is neither a land development or a subdivision, and as such, Chapter 255 does not apply. I'm sorry, can you? No, step to you?
She needs a copy.
She needs a copy of.
Insert the language.
I'm sorry.
And for I'm sorry, Norma.
Yeah, I apologize. Is it, should I be?
And, yeah, she will. And
Yeah.
for identification, Norma, this is an email from, now I've lost it. Okay, here we go. From Mr. Kachansky, dated Thursday, January 17, 2019, to Mr. Gemmer. And it is included in a package of materials that has been identified as A5.
So I had, as I alluded to, I had emailed. Yes.
So your email, in response to Mr. Kachansky, disagreed with his conclusion and made some arguments. Why don't you summarize the discussion in that email, please?
Yes, certainly. So again, so Kevin gave his opinion, and technically that's where the appeal is based upon, but the arguments I made in there will be the same ones I'll be making to you. The first argument in terms of where I feel the opinion is wrong is if you look at the definitions of land development and subdivision in both zoning and SALDO, and I know SALDO's not your purview, but just to set the level there, those are content identical, so they both have the same definitions for both. Zoning has an additional definition explicitly for development, which is we'll get to, which is the word that is used specifically in 28112F. And furthermore, if you look at 28112F, it actually uses the terms land development and subdivision as well as building permit and things in other sections. So it didn't by accident just say development in the section I'm going to talk about. So it might be good to look at that section because those arguments as well as the excerpts are all part of that email. the definition of development in 280-4 is any man-made change to improved or unimproved real estate, including but not limited to the construction, reconstruction, renovation, repair, expansion, or alteration of buildings or other structures, the placement of manufactured homes, streets, or other streets or other paving, utilities, filling, grading and excavation, mining, dredging, drilling operations, storage of equipment or materials, and the subdivision of land. So that would include, as I mentioned, I had highlighted in the email, grading and excavation and building structures, which is what Kevin was opining on with the grading and building permit. So if we look at 280-112F, where it says any plan for a development of attractive land, and doing direct substitution with that definition again because 280-112 itself uses land development elsewhere, uses subdivision elsewhere, uses building permit, of attractive land other than a single lot as defined in subsection J, which I believe is, may or may not be in there. I can talk about that, which contains slopes in excess of 14%, will be subject to review by the Planning Commission and approval by the Board of Commissioners in accordance with the requirements and purposes of Chapter 255, Subdivision and Land and this chapter. The applicant will supply the township with the necessary data to enable the township to determine whether the application is in compliance with Chapter 255, Subdivision of Land. So the argument there is that Kevin is saying, well, it's not land development, the same thing that Steve Norsini had John Rice opine upon. If it was land development or subdivision, this clause isn't necessary. The enabling or the intent clauses under subdivision, 255.3, conformance required, and 255.7, intent and applicability, say subdivisions, land development, re-subdivision, they're already accounted for under that. So this is explicitly saying, and the only place, if you look in the zoning where it's saying, it's not trying to call it land development or subdivision because it's not trying to pervert those definitions. It's saying because steep slopes are so important, and if you look at the sections like 281.12G, where the Board of Commissioners has criteria to consider when they approve these final plans for health, safety, and welfare, it's saying it needs to go through this process. It doesn't say it's a subdivision and let it flow. It doesn't say it's land development and let it flow. It says, no, any of these things that happen to steep slopes, even grading, need to go to the Planning Commission, go to the Board of Commissioners for approval, and be in conformance with 255. But it's not letting it flow the normal land development way. It's just saying that, oh, by the way, if you do this, you've still got to do these things there. It would be totally redundant if it had to be land development, because land development would do all those things without saying that. 255 saldo would cover all of that. Let me see what else.
Is there anything else you feel you need to say to make the point?
That's why I just wanted to look to see if I had any other points here. And as I mentioned in the letter to Kevin, to me, in terms of the fact that there is a definition for development, that, you know, with the Section 614 of the MPC, in terms of the appointment and powers of the zoning officer, says the zoning officer shall administer the zoning in accordance with its literal terms. And to me, the literal term of substituting in the word development, because it has a definition, which I think is very applicable here, because this, if you look at all the intents of the steep slopes and all the concerns about them, it's clear to me that's why it's in there, to say you try and do anything to that, if you're not exempt from a lot that was non-subdividable by the lot area at the time this ordinance was created. If you have a lot that's bigger than that and you have steep slopes, then or in this case greater than 14%, you need to go through this process, and technically not as a subdivision or land development, but as this side process going through the same thing, so the Board of Commissioners can review that criteria and apply conditions as necessary. It doesn't matter whether it was a subdivision or a land development in and of itself. If you're building on a lot that has steep slopes that wasn't grandfathered in to be nice to the folks that only had single lots at the time, they want to see that regardless of the scope.
Okay, thank you. Mr. Cornelia?
Mr. Chairman, may I? No, I just want to clarify the exhibit. Mr. Gemmer, I don't want to be accused of cutting you off. That's why I want to make sure, one, that are you done with your argument as well? Because I just have a question. I think we're moving on.
Yeah, I believe
Okay.
I've made that argument.
My
yes.
question, I just want to make sure, the packet I have has the pages numbered, and with what we've marked as A5, so there's like an email chain, right? Correct?
Yes,
You're including
yes.
that entire email chain, correct?
Yeah, A5 is the entire email chain.
Okay, which includes page 5, which is an email from you. I don't know if you're there yet. I don't want to go.
I'm
An email from Baron Gemmer,
there, yes,
January 7th, correct?
yes.
Okay, and that's page 5. Because the reason I'm bringing that up, because in this email, the last sentence of the second full paragraph of that email, you yourself state that the land development process of obtaining a land development process of obtaining a recommendation by the Planning Commission and an approval by the Board of Commissioners, correct? So you
I'm quoting, yeah, I'm basically
Right,
taking
okay.
from F, yes.
All right. So you acknowledge that that's where you wanted this to go, right? Is that what you were saying in this email?
Yeah, that's what I was saying when Kevin originally sent the email about the disturbance of steep slopes, which is a related but not the same issue under different 281.12 sections. I agreed with him on that, extended that a little, and then brought the larger argument for both the building permit and the grading permit at the time. As I said, it keeps changing. And yes, so I was making the argument there. When he replied, I included more details on the argument.
Okay, and then again, in the next paragraph, you repeat in the last sentence of that third paragraph, the situation is further compounded since the determination caused by the township engineer to overstep his authority and issue a grading permit in violation of 280-112F and take powers vested to the Board of Commissioners.
Yeah, my argument being if it needs to go, if 281.12F says it needs approval by the Board of Commissioners, then the township engineer, by relying upon a zoning opinion by the solicitor, which I was opining on not being appropriate, triggered that chain.
Okay, I just want to make sure that's part of that packet. Okay,
Yep.
thank you.
Okay, Mr. Cornelia?
Permit is issued on October 4th, 2018. On November 2nd, Steve Norsini tells Barron that the solicitor said the project doesn't fall under land development, and so he issued the permit on October 4th, 2018. Now we're talking November, December, January, February, March, April. 6 months later, we finally get an appeal. He's clearly beyond any 30-day requirement, whether he can even appeal this in the first place. Secondly, he's appealing with basically Kevin's confirming what the solicitor said. This isn't a determination letter that's subject to an appeal. A termination letter is generally a letter that is written to Mr. Kachansky. You pay a fee of $200. You ask Kevin, does this meet the zoning ordinance? And if it doesn't meet the zoning ordinance, what provisions does it violate? That's a zoning determination letter. That wasn't done in this case. This is something that Kevin explains to Barron why the building permit or the grading permit was issued, and Barron appeals that. I mean, it's clearly beyond the time. I can go into the merits of this. This is not a land development. The MPC is very clear as to what involves a land development, and Barron even mentions it. He mentions it in the ordinance. It says what a land development is. And it says the improvement of one lot or two or more contiguous lots, okay, one lot, for a group of two or more residential buildings, for an accumulation of condominiums, leaseholds, for a subdivision of land. Development in accordance with 503.1.1. Development in accordance with 503.1.1, again, talks about a subdivision. This is not a land development issue. The MPC is very clear on what is a land development. This is not a land development. I have cases I can show the board indicating what is a land development, what isn't a land development, and nowhere is there anything that because you have slope of more than 14%, not even steep slope. What the argument here is being made is if you have slope more than 14%, you have to go to the Planning Commission and get land development approval, and then approval by the Board of Commissioners. That clearly is not within the municipality's planning code. I had mentioned to the board this steep slope ordinance was adopted in 1977. The MPC was adopted after that, clearly supersedes any township ordinance. Finally, if you look at F, 112F, it talks about what is subject to go into subdivision. Remember, this from 1977 is invalid anyway. But it says any plan for development of tract of land other than a single lot. This is a single lot. So it's not, it's clear.
Nick, there's more than that. Than a single lot.
It's clear that the MPC, it says a single lot at the time of adoption of this code, which was in 1977, and it was a single lot in 1977 as well. This is just not, one, he's time barred. Two, it's not a land development under the MPC, does not go to the Board of Commissioners, does not go to the Planning Commission. And then three, on the merits itself, under the code, even if you accept that this code is valid, it still doesn't go to the Planning Commission or approval for land development.
If I might respond, I tried to be explicit. I was not calling this a land development. They did not try and bastardize that term and say just call it a land development, let it go through, or subdivision. They're just saying in this circumstance it needs to follow the same procedure as those, but it is not under the definition of land development. I'm not making that argument. As far as the MPC coming later, if you look at 28112, it has several sections that were updated in 2000 or later, including two that may have been affected by what Nick's referring to, L and M, which were former areas relating to lot area. But J, which he's talking about, is where you get the exception. And let's be clear, J's exception is for single lots existing at the time of the ordinance that are less than twice the size of the zoning area they're in, meaning they can't be subdivided. So that's probably a nod to mostly residential areas if they had steep slopes. They're not being harmed tremendously. They're still under the fact that when they have plans for like building permits, they still have to follow B and C, which are delineating all the steep slopes, 14 and 20% differentiated, and E, which still limits the removal of vegetation from them, unless it's for an approved use on that. And then H is for DEP. So even with that exception carved out, they still have to follow that. So the only folks that the folks that really get affected are the ones that are that existing at the time of the ordinance are greater than twice the lot area and have 14% or more. The other thing Nick related to in terms of the timing, and I brought this up earlier in the different context, but the appeal was based upon both the building permit and the grading permit. And I did a right to know and was just in yesterday, and both have been reissued or issued. I don't know if the building permit was ever originally issued even within the last 30 days. I mentioned that with the grading permit. So it's been a cycle here. So that's why Kevin's looking at this, seeing a problem. So the plans are changing. So the fact that, one, I'm trying to hit a moving target, but secondly, it's a new plan that I keep having to look at to see if it complies with the other aspects like 280, 112, D, and E, let alone F, which I'm opining, I think applies across the board, regardless of what the specific plan is in this case. F being the the 255 compliance.
So I understand the context that this is coming up in. You are appealing Kevin's opinion granted in an email that was sent 3.5, 4 months after the issuance of the permits that are in dispute?
Perhaps, probably not the building permit, and I would say the original issue of the grading permit, but it's been reissued. It was probably reissued at least once by that time, I would guess, but I'd have to look. I don't want to testify to that.
And help me with the procedure here. The reissuance, are you arguing that is a new permit?
It's certainly a change of the permit, and if the zoning officer is opining on something and either requiring change or opining on it at that time.
Well, is there any evidence in the record that the changes that are being made to the permits are a consequence or flow from the determination that the zoning officer has made? Why are the changes, and are they in direct response to that opinion?
I would obviously have to defer to Kevin on that, but the building.
Well, you're the one appealing
Okay.
it. You have to
yes,
convince
yes.
us.
The-
Don't defer to Kevin.
I can show you the original grading plan that was submitted to the Shade Tree, who approves those. And then I can show you the new stormwater, which definitely had a change because it was going through steep sloped areas. So let me see if I can find those, and I can.
And those could have been included in the prior package, or, I mean?
No, well, they couldn't have been included in December's package because at the time there was only original. So now again, I don't know how many iterations there were because even the delineation of the steep slopes has changed when I went in last week and got them. They're different places and there's more than some places than others. So the plan has been evolving even while my appeal was in progress.
Mr. Cornelia, do you have any thoughts on these issues?
As I've already mentioned, we haven't discussed the merits yet. Steep slopes are not being disturbed in this instance. We haven't gotten there, and hopefully we won't get there. But again, just to reiterate, you cannot send something to the Planning Commission or Board of Commissioners if it's not permitted by the MPC. The MPC does not allow for this type of thing going to Planning Commission, Board of Commissioners. You're talking about every permit in the township where there's 14% steep slope and someone wants to build, they got to go to the Planning Commission, the Board of Commissioners for approval. It's never been done. There is no instance where this type of situation has been sent to the Board of Commissioners or Planning Commission for good reason. It's not permitted. It's not permitted under code. It's not permitted under the MPC.
I have one question, Nick, following up on something you said a few minutes ago, and then I'll ask Mr. Gemmer if he wants to disagree with you to do so. The issue about whether this is a single lot under F.
Right.
Could you address that?
Yeah, we would present testimony that it is a single lot under F. It existed, it's not capable of subdivision. And matter of fact, Barron knows perfectly well, he beat us in court and we were unable to subdivide this lot.
Actually, I wasn't a party to that, but I do have exhibits that will counter that.
Thank you.
That's why we're building a single home on this lot now instead of two homes.
Do you want to address the issue about single lot?
No, I mean,
Okay.
enough that I understand that's an issue and disputed when we get to that.
Oh, it is a dispute, because I was on the impression it wasn't. You're disputing that it's a single?
A single lot is defined under 28112J, which is a single lot that existed at the time of the ordinance it's less than twice the area of the zoning district.
I'm sorry, Barron, are you?
No, go ahead.
Just, to sum up again, this permit was issued in October. We're talking 6 months later now. All of a sudden, we're coming back at it again under kind of doing a runaround. And let's come back at it this end now. And this is not a zoning determination. I think that's clear. Kevin's email is not a zoning determination letter.
Other than the argument, or in addition to the argument you made, Nick, and again, I hear from,
No, go ahead.
perhaps out of deference to Mr. Gemmer, I'll let him address this one first on this time, and then you second. Is there anything either in the Township Code or the MPC that helps us on the question of whether this is a determination?
I think it's written. I mean, I didn't bring case law in terms of, I've seen opinions that were done over the phone that, I don't know if they're reportable, but that have acted as an opinion that was appealable. So the fact that it's written in an email as opposed to a particular memo letter, I'm sure if it was the other way around and I had, dilly-dallied, Nick would say, well, you got notice of that and you had 30 days to do it and you didn't pick up on it, so that's why I acted. To me, he specifically says, it is my opinion, so I'll take it as an opinion of the zoning officer.
But is this a determination, or is this a confirmation of a prior determination?
No, Kevin had not, this is the first time Kevin opined on that.
I don't know that that's responsive to the question.
Okay.
Confirming what the engineer did.
Well, actually, it's a township solicitor.
Yeah, the town. To my knowledge, no, he wasn't involved in that. Matter of fact, he wasn't involved in that because in the December meeting, that's one of the reasons that it was dismissed, because it wasn't a determination by the zoning officer.
Okay, I'll try asking the question.
Okay.
Is what Kevin wrote boiled down to its essence, basically saying the township solicitor said this is not land development? Thank you very much. Or is he somehow going beyond that?
He's being more broad. He just says because it's not land development or a subdivision, it doesn't fall under there. But it's also applying it at that point to the building permit also, which wasn't a part of the December appeal. The building permit, the building application and permit, to my knowledge, didn't even exist back then. So even if you, to me, it's his first, he may be restating it, but it's his opinion for the first time.
But wouldn't the opinion from the township solicitor cover both the grading permit application and the building permit
I don't
application?
think that the opinion from the township solicitor should cover anything. The MPC doesn't allow anybody but the zoning officer to make a zoning determination. That was one of the issues. That's one of the issues I had, and reason I got thrown back in December is because Kevin wasn't involved. So this is the first time Kevin got involved, and that's why that's why I responded to him as such.
He wasn't involved in the granting of the permit or denial of the permit. I mean, I think Barron's admitted that. It was the township engineer who granted the permit.
Building though, too.
But again, we don't have any evidence regarding a building permit even before this board.
I have a copy, I think. I only have these single copies, and we can debate whether we want to bring these in, but a copy of the grading permit, date approved 3/15/2019. So this is plans covering grading of property located at 400 South Wayne Avenue, revision to grading permit 18-084, new family dwelling, filed with application 18-084A. So here's one that was just approved within the past 3 weeks. You know, literally would have been like a week before I would have appeared for you if it would have been the 21st. And I only have the one copy, we can enter that. And then the building permit, actually, I don't think I have the latest and greatest building permit because those plans were just submitted and I didn't have it. They were still the engineering copies.
I was just going to suggest, Mr. Chair, that these more recent permits are irrelevant to this consideration.
Yeah, I do not see them as different permits. I mean, they are perhaps enhancements to previously issued permits, but.
Well, I mean, they're, they're literally different permits, different dates on them. Matter of fact, they even have one was granted to Rockwell, the other was granted to 400 South Wayne LP. Yeah, the older one was granted to Rockwell Glen LP, the one from October 4th, and the one that was approved March 15th of this year was granted to 400 South Wayne LP. So they're even granted to different people, different entities.
Nick, is there any light you can shed on that?
Again, I don't know. I mean, it's his burden to proceed, so.
Mr. Gemmer, do you have any, but for the issued permits, do you have any visibility into how it came to be that they were issued to different recipients?
No, I know that 400 South Wayne LP, I believe, is the owner per the county records. And I can.
I can admit that, yeah. One's the builder and one's the owner.
Yeah, and the thing, from my standpoint, Rockwell, my understanding is Rockwell Glen, I've been told, is the equitable owner, but I made a specific right to know request, and the township could provide no evidence that Rockwell Glen had any equitable ownership, and they've been signing some of these permits, too. I don't know what.
Hey, that may be accurate, that they're the equitable owner, and then, so present here are both the equitable owner and the current owner.
Yeah, that's why I didn't bring it up, because I figured that was fine, but it's more, just so I could clarify from Nick, is it just the builder or equitable owner?
I don't know if it's relevant or not.
Okay.
Mr. Chairman, if I
Park
could
line is
suggest, I
both-
mean, based on the comment you heard from the board, I think even if anything was changed, I mean, your appeal addresses a specific email decision opinion
Well, that's
that
fine.
you're appealing. Well, let's focus on that,
I'm-
because I think you might be mudding, you might be making things a little
All right.
worse.
I will stop muddying the waters.
I don't know what the board's view is. I would like to be counseled a bit by our solicitor before proceeding further with this matter. So we're going to go into executive session for 15 minutes, and we will reconvene at 9:20. Thank you. All right, we are back on the record. Before proceeding, I would ask the board whether it would be helpful to hear one final summation from the parties on this before we consider motions and discussion. Would that be acceptable to everyone? Mr. Gemmer?
Try and help Norm out. I'll obviously be reiterating a few things, but this is not a land development or a subdivision, but the code is explicitly calling for it to go through the same process because of the importance of steep slopes and health, safety, and welfare, which goes to the sedimentation, erosion, and stormwater management, which is why it manages vegetation removal, which is why it has specific, in most cases, has specific use restrictions, except for the lots under J. So that's why it warrants this more explicit process for any lots that weren't grandfathered out of this in deference to those smaller ones. And again, I think it's worth noting that both Saldo and zoning have the same definition for land development and subdivision. They made those in sync, but there's an additional definition for development explicitly in 280-4 in zoning, which would be a direct substitution into that section, which so basically saying if you're doing any of that grading, if you're doing anything to the property that isn't exempted under J, that it's twice the lot size of whatever area it is that has slopes 14% or greater, the Board of Commissioners and the Planning Commission want to look at it to apply the criteria that's specified in 281.12G because it's that important. As we know how important stormwater management is in this township, maybe it wasn't as important back then, but they did realize that runoff and things on neighbors' properties and et cetera were important. So the preservation and the appropriate development around whatever slopes, 14% or actual steep slopes, was a very important thing to them. And as I said, Nick says it predates the MPC, but then there were plenty of at least 4 or 5 additions, or excuse me, modifications to that code since, which would have probably taken into account any issues that it needed to. And I'll just, in closing, just say that going back again to the MPC, it talks about the literal enforcements, and to me this is a pretty simple word substitution where the definition is sitting right there and is applicable to both grading and building permits and activities.
Thank you. Mr. Cornelia?
You've already heard my argument regarding this is not a zoning determination. This was Kevin just reiterating what the township solicitor had mentioned. Kevin can confirm that to ask for a zoning determination, you have to pay a fee of $200. You submit a plan, you submit a letter, and Kevin makes a written decision. That wasn't done in this case. But going beyond that, and again, he's appealing something that happened 6 months ago. Looking at the provisions of the MPC and case law, which I haven't handed up to the board, the MPC governs what the townships can do. 501 of the MPC states all powers granted herein to the governing body or the planning agency shall be exercised in accordance with the provisions of the subdivision and land development ordinance. And I can hand that out, but it's pretty clear what it says. Yeah, I'm sorry. Then 107 of the MPC actually describes what a land development is. And interestingly, it does mimic the exact language that's in the township ordinance regarding what a land development is, which means what needs to be submitted to the Planning Commission or Board of Commissioners for approval. And as we mentioned, that it says it's a subdivision of 2 or more buildings. This involves 1 building. Finally, there's a case that I like to hand up is Maturano versus Board of Commissioners of Cheltenham. Basically, the court in that case, the Commonwealth Court, said that the township subdivision and land development ordinance may not validly regulate, in this case it was a commercial building, when the MPC doesn't define that as an item to be regulated. Nothing in the MPC defines that slopes 14% or greater are to be regulated and must proceed to approval by the Board of Commissioners or the Planning Commission. It's clearly against the MPC, even going beyond the issue of whether this was a timely appeal. I'll hand that case up as well. That's yours. Is that yours or mine? Okay. Thanks.
Thank you. Are there any members of the public who wish to be heard on this matter? No. Okay. Yes, yes, please swear the witness.
Yes. My name is Richard Butkosk. I live at 325 South Wayne Avenue, across from the property. Excuse me? Butkosk. You can't get that phonetically? Just for clarification, there seemed to be some confusion. I attended the original dismissal, which I guess was in December. My recollection is there was no discussion of the actual issues. It was just a jurisdictional question. There was no discussion about the merits, the issues being raised, or what the issue was that was being appealed or anything. For a little quick history lesson on this, there's a 14-year history with the neighborhood with this property with the same building owner. 14 years ago, there's an application for subdivision that was denied. In 2005, the owner appealed that to the town, appealed the township's decision. The neighbors intervened in that case, and neighbors successfully defended the denial. The township, frankly, did nothing to defend their case. At that time, the solicitor and the township officials basically stood in the background while they let the neighbors defend their case. That really kind of went down pretty poorly with the neighborhood. 14 years later, we have many of the same issues. There's a lot of concern with the same owner in terms of how we can rely on the township to follow the letter of the law and the ordinances that are in place right now. The neighbors are certainly looking to see this property developed in some fashion. We're looking for an appropriate solution on a, frankly, odd triangular lot that fronts on two streets with steep slopes. It's difficult to imagine throwing many more different wrinkles into a design problem. Our issues are, frankly, looking for the township to follow existing regulations and the appropriate steps to get there, including compatibility with steep slopes and multiple mature trees on the property. Some of the things that I'm concerned with right now are that, I guess, having watched 3 different appeals go through tonight, and my heart goes out to you guys. I guess you guys all volunteer your time to go through this, which is, if that's the case, you have a lot of patience. I have concern, number one, for fairness for all parties, not just the neighbors and people and Barron who's appealing this, but also for the owner and the contractor he's trying to produce a development with. It's a time issue, and I'm concerned that we're all ticking away precious time on the clock. As I'm looking at things that went on this evening, there were 3 different cases that were brought up this evening. I see one where Villanova University has apparently been in violation of something that was agreed to by the township.
Sorry, I have to, Jeff. This has no relevance to the
Please, let's just stick to the issues on this
Okay.
appeal, please.
I'm concerned that we've gone through two issues that seem to have kind of pushed along and try to see if they can accommodate things that are in favor of
Again,
the
sir,
people involved.
I have to ask you to stick to the questions
My
that
concern,
are germane to this
my
appeal.
concern here is there is a lot of time being spent on very specific innuendos in terms of details about timing, things of that sort. I understand a grading permit has just been reissued. The question in my mind is whether that starts a 30-day clock again. Drawings that I've seen appear to indicate a larger building footprint, yet the steep slopes seem to be farther away from the building than they were in a previous submission. There's a timing issue. I know it's an issue for both sides, but I am concerned about fairness in terms of making sure this thing is following regulations that are on the books. It's as simple as that.
Thank you. Seeing no other commenters, let's ask for motion so then we can start discussion. Would someone like to make a motion?
I'll make a motion, move to deny the party's appeal because the email in question does not constitute a determination separate from the grading permit, and as such, it's not appropriate for appeal to this board.
Second?
I'll second it.
Okay, discussion?
I sort of said in the motion, I think that there's a policy issue here, which is this was part of some back and forth with the township zoning officer. And again, I don't think it was intended to be a formal determination. And I think that to the extent we end up causing such, allowing such items to be subject to appeal, we drive staff toward not interacting with neighbors and residents because they run the risk, they have to get their lawyer to read every email they send. I don't think this is something that triggers the right to appeal to this board.
Briefly, I concur. I would not want to have the township staff shy away from answering questions of the public. And, I kind of read that email as a dialogue between citizenry and the township.
I kind of agree. I would hate to think that you can't have a conversation without it coming back to bite you. I don't think Kevin was giving any credence to the ruling. I think at some point there's a process to go through. You pay your $250, you get your opinion, and that was never really taken to heart. So I'm not in support of moving forward.
Okay, if there's no other discussion, I'll call the motion for a vote. All in favor of the motion to deny the relief requested, please indicate by saying aye. Aye. All opposed? No? The application is denied. We'll meet again on the 25th of the month, the 25th, not the 18th, the 25th of the month, and we're adjourned.